Hey, everybody. Thank you so much for joining us at our webinar today. Today, we're going to be talking about what the new updates were in SB 91 and answer some of your questions about what might be happening since that law was passed. Answer any questions you might have about the state rental assistance program, and then answer any other questions you guys might have about just landlord tenanting in general, whether it's COVID related or not COVID related. So just as a reminder, I see a lot of my very valuable clients are here, so they know a little bit about us. But for those of you who are not yet clients of our firm, just a little bit about what we do. We're a full service real estate, landlord, tenant, and construction law firm, handling litigation and transactional matters. So basically, we're a one-stop A to Z shop. If you are in the real estate business, if you're a landlord, developer, property manager, investor, or anything like that. So if it's loan docs or purchase and sale agreements, or if it's a problem with your tenants or having to do evictions or contracts or problems with your contractors or architects, engineers, basically all of that stuff from a holistic perspective, we offer all of those services. We're a 6-attorney firm, and basically here to help everyone in the real estate industry navigate what have become very troubled waters recently, as I'm sure I don't have to tell you. So I wanted to do a quick recap of SB 91 for anyone who hasn't been on any of the prior webinars. And in order to do that, you got to do a real quick recap of AB 3088, which was the statute that SB 91 updated. So as you guys may recall, in September of 2020, the state passed AB 3088, which is the Tenant Protection Act, in the wake of COVID and the prior emergency rules preventing most UDs from happening having been expired by the courts. So essentially, what happened was most no-fault evictions were canceled. So such as landlord residency, family residency, Ellis, resident manager residency, all of those kinds of things were pretty much canceled. You could still do things like cash for keys. There's still other avenues you could go to put pressure on tenants, but most of that was done with. In terms of non-payment of rent, as you may recall, also, there were 3 periods that were created. There's a March to August period, August 31st, March 1st to August 31st, where you just gave them one 15-day notice. It's 15 court days now. And if they provided a declaration saying that they couldn't pay the rent during that period due to a COVID-19 related circumstance, basically all of that rent turned into consumer debt. You couldn't evict them anymore for it. Same rules applied for each month of September 2020 going forward. And you gave them a new 15-day notice every single month. And originally the dates were till January 31st. And January 31st of 2021, the protections were supposed to expire. And as you also may recall, if the tenant signed a declaration for the September to January period for each of the months, and they paid 25% of all the rent that was due from September until January, then the other 75% also became consumer debt. You could never evict them for it. And then going after that, it was back to normal. So what's going on now with SB 91? What sort of changes have been implemented? Some of the ones that don't have to do with the 15-day notices and the payment of rent is, number one, they were very specific to say you can't discriminate against a prospective tenant who has COVID-19 debt. So theoretically speaking, what they're expecting you to do as a landlord or a property manager is have someone who comes in, somehow hasn't hit their credit, but they have $25,000 in COVID debt. You somehow actually found out about it, and you're not supposed to discriminate against them based on that. Now, obviously, if you've asked them questions about it and they give you answers about it, and all of that's in writing or with witnesses, and they have no other reason that you could possibly reject them, then yeah, that creates a problem. However, we can always talk about this offline as well. There are usually reasons you can find to reject the tenant, especially if they're in a significant amount of COVID debt. Chances are their credit is bad, and you can reject them because of that. And there are a whole host of other reasons that you can legally reject a person. there are more conversations that are circumstance specific and better to have offline. But just as an overall rule, they specifically said that if you're rejecting someone, if you write an email to someone and say you cannot come live here because you already owe some other landlord $25,000, and that $25,000 was incurred during COVID, that would be an unlawful discrimination. So do not do that. You also can't sell or assign your COVID debt, which basically means, let's say you have in your portfolio $250,000 of COVID debt altogether. You say, you know what? I don't want to deal with this. I'm just going to sell it to some collections person, 10 cents on the dollar. I don't care. Here it is. You go collect it, right? You cannot do that until July 1st for most people. And you can't really do it ever for people whose income is at or below 80% of the average median income for the 2020 calendar year. And depending on where your unit might be, that AMI is different. Okay, for someone who has COVID debt, you can't charge late fees, ever. So for COVID-related debt, late fees are gone. You also can't increase fees on services that used to be free. So for example, let's say you provided some sort of amenity, whether it's a utility that you paid for, or another kind of service that you paid for. If they're not paying their rent and you didn't used to charge for that service, or you didn't used to charge for that amenity, and now you say, fine, well, if you're not going to pay the rent, I'm going to charge you $100 extra for the gym room or this jacuzzi or the free laundry or the water that we pay for, that you cannot do. So that's also a retaliatory and illegal rent increase. There is one silver lining, however. The opposite is also true. If you have decreased or temporarily reduced a service or made a service unavailable because you are trying to comply with the federal, state, or local COVID law, that is not considered a breach of your lease. It is not considered a reduction of services. It does not affect the maximum allowable rent if you are in a rent-controlled jurisdiction or if your building is subject to the state rent control. So we have actually a lot of clients who provide really great amenities like barbecue pits and jacuzzis and roof decks and little roof bar areas and places where people tend to go to congregate. And those were all closed. A lot of tenants complained and said, well, that's part of my rent. That's part of what I'm paying for. I want a rent reduction. Or you're breaching your lease because it says you're supposed to provide that in your lease and you're not providing it to me. So I want a rent reduction. Well, in this particular case, the law has been favorable to landlords and said that is not true. As long as you are closing it in order to try and comply with the COVID restriction, then you are safe. Now, keep in mind that those COVID restrictions are changing right now. In Los Angeles County, for example, we just went up from the purple to the orange tier. They have now met 2 out of the 3 guidelines to go from the orange to the red tier. So thank God the numbers are coming down quickly. As the numbers come down, the restrictions go off. And so you may want to start thinking about reopening, at least in a limited capacity, some of those amenities and some of those services. Which ones, how much, how do you open? All depends on your building, your tenant makeup, the kind of restrictions that may still be in place in your particular area. So it's call your local landlord, tenant, real estate attorney to ask about those specific kinds of questions. But generally speaking, you might be able to start opening those up. Because you might be able to, it may not be legal to keep them closed at a certain point. All right, so the protected period, right, is the same. The old March to August period, they didn't change that. However, the January 31st date that was originally supposed to be September 1 to January 31 now got moved out to June 30th. All the other dates that were post September 1 also got moved out by 5 months. So what does that mean? It means that now no one had to come and pay rent by 25% by January 31. They have to come and pay 25% of the rent that became due from September 1, 2020 through June 30th, 2021 by June 30th, 2021. If they do that, the other 75% of all the rent from September 1 to June 30th, 2021 becomes the consumer debt. The rest of the rules apply the same. Except for now on June 30th, instead of having to pay about a month and a quarter's worth of rent, they're going to have to pay 2.5 months worth of rent. And I think that's going to be difficult for people who haven't been paying since September. If they don't do that, they are subject to an eviction action. Okay, what happens to civil complaints? What a lot of landlords are doing, and what our office is doing a lot of, is for tenants who were basically immune from getting evicted because they were filling out all the declarations, and they were following all the rules. Initially, there was nothing to prevent you from filing a civil complaint in regular court, not small claims court, but regular court, to enforce your rights under the contract that is your lease. Because remember, your lease creates a dual system of privity between you and your tenants. On the one hand is what's called a privity of estate, an old English common law concept, which is still valid in today's law, which essentially says, I have property, I'm letting you borrow it. You owe me the reasonable value of it. That's called privity of estate. However, you also have a lease, and that lease is a written contract. And because you've entered into it with your tenant, you also have privity of contract. When you go and you try and get possession, what you're trying to do is effectuate your statutory rights as a California landlord, but really they're based on your rights as under privity of estate to get possession of your property. When you go and you sue in a regular court, that's a breach of contract action. You might not be able to get possession back in a breach of contract action. You can't. But you could have still sued just to get the money that's owed. And the real purpose of doing that was to use that as leverage to get them to voluntarily leave. Well, unfortunately, the legislature caught up with that idea, and they said, number one, all actions to collect COVID debt, are not allowed until July 1st. If you have one that's already been filed, it's stayed. If you have one that was filed before October 1st, it doesn't get stayed unless the defendant makes 80% of the AMI or less, in which case it does get stayed. So essentially 95% of the actions are either stayed or postponed. You can't file them until July 1st. All right. Now, what happens to small claims actions? As you might have heard in AB 3088, not all landlords are huge landlords with thousands of units. Some landlords are very small, mom and pop landlords. Maybe they only own 3-4 units. And for them to go out and get a lawyer to try and collect the money, even if the person's left, was very expensive. So the legislature said, fine, we will open up the small claims courts to you. We will, if you're trying to get COVID debt, we will eliminate the caps on the amount you can go, because if you're an individual, it's 10,000. And if you're a corporation or other entity, LLC, partnership, what have you, it was 5,000. And they say, if you're trying to collect COVID debt, as much as you want, go ahead and you can get that in small claims. They also eliminated the cap on the number of claims you could file, because it was usually 2 in a period of 12 months. If you're trying to collect COVID debt, unlimited, right? But that was supposed to start back in March 1st. Now you can't file any of those small claims actions until August 1st. Further, there's limits on attorney's fees in any of these actions, which is $500 for uncontested, $1,000 for contested. Uncontested means it went by default. Contested means they filed an answer, and then you got a judgment. Now, most good leases have these limits in them anyway. And these are good limits to have, because in the event that you lose a UD, which especially in the more populated areas like LA County, or San Francisco, where there are agencies which will provide free legal services for these tenants, and all they do is get tenants out of UDs, right? You don't want to end up with some $15,000 or $20,000 legal fee after this just because you lost on a technicality. So these attorney's fees are actually quite good. Sorry, the limit on the attorney's fees is quite a good thing. Okay, security deposits. This has become a really important question. With regard to security deposits, when the tenant is still inside their unit, you cannot use the security deposit to pay for any COVID debt. You simply just can't do it. However, after they leave, their tenancy is done, there is nothing preventing you from using the security deposit to pay for any unpaid rent, just like you would when it wasn't COVID. So you follow the exact same procedure you would even to pay COVID debt. Now, this is very important. What happens to the discrepancy between the local laws, all the local moratoria, and the state law? So, if a local entity tries to change their moratorium between August 19th, 2020 and June 30th, that doesn't become effective until July 31st. Now, until July 1st. I haven't really seen any of them do that other than to extend the dates to be coterminous with the state law. So that one doesn't really apply. However, this one is important. If the provision in effect on August 19th, 2020 required the repayment to be any later than August 31st, 2021, that part's invalid. So, for example, in the city of Los Angeles, we have a local moratorium that A, doesn't have an expiration period, and B, says that once the local emergency expires, tenants have a year after that to pay the rent before they can be evicted for it. The state law says no, you cannot have that period extend beyond August 31st, 2021, which is very good because, relatively speaking, August 31st is really kind of around the corner, and it would have been very difficult on landlords if they had to have waited until July 1st, 2022 before they could start evictions. Now, August 31st, 2021 is the end date according to the state law, and the state overrules the city. All right, state rental assistance. The site is up. If you go to housingiskey.com or the housing.ca.gov website, you can go ahead and follow all the different prompts. However, it will start to ask you if you live in a particular city or county. Some of the cities and counties are running the programs themselves. So it's still the state-sponsored money. It's still the money from SB 91, but it's being distributed and administered by a local entity. For example, in the city of Los Angeles, it's unfortunately being administered by the Housing and Community Investment Development Department, Housing and Community Investment Department, HCID, Housing Department, right? They decided not to open up their procedures until March 30th. Is that a violation of the law? Absolutely, yes, it is. Does anybody care? No. Unfortunately, you're still going to have to wait until March 30th if you have units that you want to apply for in the city of Los Angeles. A number of the other counties and different cities who are self-administering have different dates on which they're starting, but if you are not in one of those cities, or if your building that you're trying to get the relief for is not in one of those cities or counties, you can go ahead and start filling out your application. The way it works is that they'll ask you for some really simple information, such as the tenant's name, the tenant's email, how much they owe, copies of the lease, copy of your W-9, how you'd like to be paid, check or ACH. And then you just upload all of that information. They then will go out to the tenants and start asking them for information. And it's incumbent upon the tenants to cooperate. If you're finding that tenants are not cooperating, something that we've done in the past, at least for tenants who are not in term anymore, in other words, they're month to month, is you issue them 30-day notices of a change in terms. And the change in terms is that it is now a lease obligation for you to cooperate with the landlord with respect to any attempt to get government assistance to cover your rent. Now, in the city of Los Angeles, you can go ahead and do this. Can you evict them for not cooperating? No, because that would be a violation of rent control. Under rent control, which still applies, if you try and change the terms of a lease and the tenant doesn't actually sign on that change of terms, you can't evict them for violating the unilateral change of terms. However, outside the city of LA or West Hollywood or Santa Monica or other places that have similar rent control statutes, you can, in fact, attempt to evict them at least for violating that provision of the lease, which became effective 30 days afterwards. So at least it lights a fire under them to make sure to cooperate with you. And it could also very simply be that the tenant simply doesn't understand. The government is all of a sudden calling around, asking them for information about how much money they make and how much rent they didn't pay. They might just get scared and not understand. So it's also, I think, incumbent upon all the landlords and property managers to provide sufficient information to say, hey, look, no, the government wants to give me money to pay your rent. So you don't have to pay it, and I can't evict you for it, and you're getting a 20% break. Remember that if you take any of the money from the government, it's up to 80% of the rent, and the other 20% is forgiven. It is not consumer debt now that you go and collect later. It's forgiven. It's done. It's over. You are waiving 20% of that rent. So I think it's incumbent upon everybody to make sure that your tenants are aware that if they get a call or an email from the state, to cooperate, because it's helping them, not hurting them. Some of my clients have asked, should we even take this deal? We have to waive 20% of the rent. The answer is yes. If the state will give you 80% of the rent, even if you are giving up the right to the 20%, even if you're giving up the right to evict that particular tenant, if that tenant isn't paying the rent, getting 80% is a really good deal, right? And remember, it's only the rent that accrued from April 1, 2020 to March 31, 2021. Those periods are long. March 31 is almost over. So if you can get 80% of the rent from that time, and then they start not paying the rent in April, May, June, July, you're still going to be able to evict them a little later. You might as well get back that money, because if they haven't paid it to you, chances are you're never going to see it unless the state gives it to you. So go get your money. Now, it's going to be doled out. It's supposed to be in 3 rounds. It's really 4. Round 1 is people who are making less than 50% of the average median income. So these are really low income people. Round 2 is communities who are disproportionately impacted by COVID as determined by the state. Who is that? It's probably going to be poor areas, and as the state has disclosed, places that are largely populated by peoples of color. Round 3, it's supposed to be everybody else, but they say in round 3 that they're prioritizing households of 80% AMI or less. So round 3 is really 2 rounds, all the people who are making 80% or less of AMI, and then there's everybody else. Okay, now if you refuse the 80%, let's say for whatever reason you feel like that's not a good deal for you, and then you want to go and sue the tenant for the full balance, a judge is permitted to reduce the award by the amount you could have gotten from the state. Even if they're reducing it all the way down to, say, 25%, and really that 20% is something you couldn't have gotten, the judge is allowed to reduce it quite significantly. So really, you have every incentive and some reasons, and some definitely good reasons, some sticks, to take the 80% deal. So that's pretty much a summary of everything that happened in SB 91. I see that we can get to the questions now. So I'm sorry, I'm just going to take a quick sip.
Steve, we do have a few questions.
Great.
The first one comes from Sarah. She asks, is there anything in SB 91 regarding commercial tenants and other tenants, I believe, who haven't paid rent? What, if any, notices can be served, and what, if any, rent can be collected?
All right, let's talk about commercial tenants. Very simple answer, AB 3088, SB 91, none of it applies to commercial tenants. Both of these state laws apply strictly to residential tenants. So what is going on with commercial tenants? Basically, they're still under whatever local moratorium applied to them before. So if they're in the city of LA, that's what applies. If they were in the county of LA, that's what applies. If you're in some other area, whatever the local moratorium was, that's what applies. A lot of people misunderstood and believed that there was some sort of state moratorium on commercial evictions. That is not true. What there was is back in March, the governor issued an executive order, N2820, in which what he did was he unshackled the state laws, which would make it otherwise unlawful for a local entity such as a city or a county to pass laws limiting a private landlord's ability to do commercial evictions. So let's say there was no COVID, right? And the city of LA decided, businesses are hurting. We're going to have a 1-year break on commercial evictions. Could they do that? The answer is no. That would be completely unlawful according to the state law and the state constitution. The state puts protections in place to prevent cities and counties from going rogue. But because of the emergency, the governor essentially temporarily lifted those restrictions and allowed the city and counties to do what they did, which is pass their local emergency moratoria. That N2820, as you can see, is not a moratorium in and of itself. It just gives the permission to pass the local ones. And it did it for a limited period of time and for limited circumstances. For commercial tenants, it was only to say you cannot evict commercial tenants for non-payment of rent. And you can only have that rule in place until, back then it was May of 2020, and that got extended and extended and extended. Most recently, in this past month, it got extended to June 30th. So any local city or county moratorium that has a provision in it that says our moratorium provides for the moratorium on commercial evictions, and it goes till whenever the state allows us to go till, or N2820 as it is extended, then that city's moratorium goes until right now, June 30th, 2021. What does it prevent you from doing? It prevents you, in most cases, from evicting a commercial tenant due to non-payment of rent as a result of a decrease in income because of COVID-related circumstances. It does not say that if you have any decrease in rent, then you can't evict them. It doesn't say that if they're doing just fine but decided not to pay their rent, that you can't evict them. So it's usually, most of the local moratoria are couched in that way. Now, this is very important. What happens if you have a commercial tenant who is out of term? They're month to month. Can you evict them? Yes, you can. You just do a 30-day notice to vacate because their lease is over. And nothing in at least the legal moratoria, at least, for example, in the county of LA or the city of LA, prevents you from simply exercising your rights under the lease to say, hey, look, the lease is over. This is something you cannot do with pretty much all residential tenants right now due to COVID, but commercial tenants are completely different. Now, I have to warn you that there are, anywhere from 50 to 100 local moratoria throughout the state. So if you have a specific question about a particular area, I think it's important that you call us or email us so we can make sure that we're giving you the right information. But I can certainly tell you that for the city of LA and for the county of LA moratoria, both of them are as I described. You can't evict the commercial tenant for not paying the rent, but if they're out of term, you can simply do a 30-day notice to vacate. Also, you can sue them right now for a regular civil collections action and use that as leverage to get them out. That's something you can't necessarily do for residential tenants right now. That's what we just discussed. That rule doesn't apply to commercial tenants. So I'm going to try and go through all the questions here. So Eitan Tashman asks, do all the rules about small claims court apply to commercial properties as well? Not really, because COVID-19 rental debt is defined in SB 91 as the COVID rental debt from those residential tenants. So pretty much no, it doesn't apply. Alyssa's, will this be recorded? Leonard, I think you said it is being recorded, so you'll be able to access it. Where can they access this, Leonard?
It will be on the blog tomorrow.
Great.
And we'll provide that blog link in the chat as well.
Great. Okay, so additional clarification on the August 31st information. Is that saying tenants no longer have 12 months after the end to pay back the rent? That was a bit confusing. Okay. Yes, basically. If you're in the city of Los Angeles or in the county of Los Angeles, both of those moratoria have provisions that say at the end of the local emergency period, they have residential tenants have 12 months to pay back the rent before you can be evicted for it. The way the state SB 91 statute reads is it says you can't do that, local city or county. Your provision that allows them 12 months after the local emergency period, it basically has to come back to being, the payment period has to end on August 31st, 2021. Is that clear, Sarah? Hello?
Yep.
Yeah.
Sorry, yeah, I'm here. Yes.
Okay, cool. Okay. So Molly says, we submitted some residents for the program, the state assistance program. You can do follow-up to get the information the state needs to proceed. There's nothing preventing you from knocking on their door and saying, hey, did you know that the state is giving away free money to cover you? Can you please help answer these questions? Don't harass the tenants, obviously, but you can do some gentle nudging, phone, email, if they're not technologically accessible, the knocking on doors. You can also just put up notices. If you'd like, we can help you prepare them that basically say, hey, if you get a call from the state, they're not trying to catch you. They're not trying to put you in jail for not paying the rent. They want to give you free money. The money does come to the landlord, but it's to pay your rent. It's to pay debts that you would otherwise have to pay and to cancel 20% of the rent. So if you couch it in those terms, hopefully that will give them enough of an incentive. So yes, you can do some gentle nudging. Do I expect the date to be extended? I will give myself one small pat on the back. Back in January, when everyone was wondering when they were going to extend the date, because in January, if you'll remember, the numbers were out of this world, and there was no way they weren't going to extend it. Even in December, one of the state legislators put in a bill to extend the date all the way out to December 31st. And I predicted at that time, I said, that's not going to pass. It's not going to fly. They're going to extend it till June 30th. And I got it right on the money. And the reason I picked June 30th was because I figured that by that time, all the numbers are going to be down significantly to the point where it just really didn't make any legal sense or really any business sense to continue the restrictions beyond that date. Thankfully, that has come to pass. In most places in California, the numbers are going down significantly. Vaccinations are going up significantly. Deaths are also going down significantly. I think unless we have another surge, and there's really no basis for another surge because the prior surge happened due to Thanksgiving, Christmas, lots of people getting together, lots of people traveling. So they were bringing all the COVID from all the other states back here. What do you have now? You have Passover and Easter. You can't compare those to Thanksgiving and Christmas in terms of people getting together. And it's within a framework back then of nobody being vaccinated, and now you have people getting vaccinated everywhere, every day. So do I think it's going to be extended? Optimistically, my answer is no. So it's just a prediction. It's just speculation. I have not heard this from anybody, but I think the lobbyists will have more than enough power and numbers and information to really put the legislature on their heels if they try to extend it further. For residential, if a tenant has filed for rental assistance and they're on a month-to-month contract, can we end their tenancy for July 1st? So first of all, again, this depends on if they're in rent control. So you have your state rent control, your county rent control, your city rent control. So Rachel, that would depend on if they're in rent control. If we're talking about a tenant, well, just so I can answer your question specifically, what kind of tenant are we talking about?
Not in rent control.
Not rent control. Good.
Thank
So
you.
if we're talking non-rent control, yeah, July 1st, 2021, you can send them 30 or 30-day notice if they've been there less than a year, 60-day notice if they've been there longer than a year. I don't believe that applying for the rental assistance necessarily has any impact on that particular right that you have. So Tim is asking, if a landlord wants to raise rents on tenants that are currently month to month and they're exempt from the just cause and the rent control, is there any reason they can't raise? Can the tenant state they can't afford the raise due to some cause? So If you have no rent control, no state rent control, nothing like that, can you raise the rents? Yes. Yes, you can. The only thing that would prevent you from raising the rents beyond, say, 10% is the fact that the state is under a state of emergency and there are anti-rent gouging laws, which would, in most cases, prevent you from raising the rent more than 10%. But that's really the only restriction. Can the tenant then state they can't afford it due to COVID? Yes, they can. So I just had someone call me about that and say that they had a unit for $2,850 and no rent control. They wanted to raise it to $3,050. Yeah, that's even within the 10%. And the tenant said exactly that. They said, sorry, we can pay the $2,850, but we can't pay the $3,050 due to COVID. So you are potentially subjecting yourself to that defense.
Niv, we have another question that came in from Molly. She says, what can we evict on that will actually stick in court?
Okay. Well, look, it all depends on your judge, on your court, on your local area, right? And it depends on the facts of the case. We had a situation where we had a former Dancing with the Stars person. I think it was Dancing with the Stars Australia or New Zealand or something. So it's not someone you would have ever heard of. But they were on TV, and he says he lost his job because of COVID. And we said, nonsense, you have plenty of money. And we tried to do the eviction, and the guy came in with no evidence whatsoever. I mean, zero, nothing. Not a letter from the network, not a letter from his agent, nothing from his manager. Zero, zero, zilch. And the judge said, well, he filled out the declaration. See you later. In Los Angeles, that's probably what's going to happen. Outside of LA in San Bernardino, we're evicting people left and right. We're getting people out on stipulations. Obviously, in order to make those kinds of deals, you have to be willing to waive some of the back rent. But if you have people who didn't pay during these COVID times, your back rent is gone. You're never going to see that money unless you're getting it from the state. So you're basically just paying them with monopoly money as far as I'm concerned. So it is very, very locally dependent. Now that's for rent issues. For everything else, your nuisance evictions, breach of lease evictions, all those things are still wide open. You can still do them, no problem. And those, if you have the backup, if you have the evidence, they should still stick. There's really no reason for them not to stick. And we have been prosecuting a lot of nuisance evictions because COVID has caused an uptick in the craziness.
Niv, our next question comes from Maurice. He asks, isn't it true that anyone making over 80% AMI does not qualify for rental assistance program? I have a tenant that is a high income earner and owes over $40,000. What is the likelihood that the owner will get the 80% rental assistance?
Likelihood all depends on how much of the money is used up by the people who have priority. So it's not that you can't get it, it's just that you're at the bottom of the priority list. So it goes first people who are doing 50% or less, then the people who live in places that are disproportionately impacted, then the 80% people, then everyone else. Now, they may have a bunch of money left over afterwards. We don't know yet, because I don't think a lot of people are calling our office and having us do the applications for them, because especially if they're mom and pop, the whole thing is just Chinese to them. So if you have a lot of people who just don't know about the program, don't know how to apply for it, don't know how to get through the application, don't know how to get their tenant to cooperate with it, or can't get their tenant to cooperate with it, that takes a lot of players and a lot of the people who would otherwise qualify off the board, leaving more money for everyone who's at the bottom of the totem pole. So because it's such a new thing, I mean, today's the 23rd, so it's been open all of a week. We really don't know yet, but I would go ahead and apply right away. Make sure you get in there so that by the time they come to your guys, you're close to the front of the line for your tier.
Our next question comes from Tanya. She says, this is for Los Angeles City. Would a resident still qualify if they applied for the emergency rental assistance program they had last year?
Hey, Tanya, how you doing? As far as I know, yes, they would still qualify. I haven't seen anything in the statute which disqualified them. And anything like that wouldn't really make much sense, because I think the emergency rental assistance program, you're talking about the one from the city, was only like $2,000 one-time payment. So this program is designed to be a lot more inclusive, obviously. So if you took out all the people who got the $2,000 from the city of Los Angeles, it just really wouldn't be fair. So as far as I know, that would not be a problem.
Our next message comes from Sarah. Are the moratoriums still in place for not being able to evict due to additional tenants in the unit? At one point, there was something where you couldn't evict for an unauthorized occupant due to COVID.
Correct. Yes, it is still in place, especially in the city and the county moratoria. And it is still in place in SB 91. It also applies to pets. I haven't really seen anybody in practice who could actually show the evidence to support that, right? Because you'd have to have someone who was kicked out of their unit, had to come into your unit for some reason. To date, for the last year, haven't seen a single case where they could actually show the evidence. But yes, theoretically, if they could, that is still in place.
Niv, we have another question in regards to what we've discussed here and what was asked previously. Terminating a month-to-month lease after the 12 months is over, would you need just cause?
Depends on if you're in a, depends on if we're talking about before June 30th or after June 30th, and it depends on if you're in a state rent control or local rent control area. So obviously, if you're under state rent control, then absolutely, COVID or no COVID, you need just cause, or one of the no fault just causes. If you're in a city or county rent control, same thing, of course. If you're outside of one of those and it's before June 30th, then yeah, you can't do one of those evictions right now. After June 30th, so long as the date stays, then you're free to go. You can do whatever you like. Now, I just want to clarify something else too. The way the law works is that a judge is not allowed to find a tenant guilty of unlawful detainer before July 1st. Where does that make a difference? It makes a difference because you might be able to give the notice in advance of the July 1st, so long as the notice doesn't expire until after July 1st, right? So again, it's very, very unique circumstances. If they apply to you, give us a call, give us an email, and we can see if that applies to you. But certainly there are places where you can play with this, because it doesn't say you can't give the notice before July 1st. It just says, if we're talking about terminating a vacancy on 30 or 60-day notice, it just says the judge can't find you guilty of unlawful detainer before then. That's the date of the trial, right? So there may be some options there.
We have another question about rental increases from Molly. She's in Sacramento and she understands that she can increase by 6%, but I guess in LA we can do 10%.
For rent increases, so the way it works is that if you're, Molly, are we talking about rent control or non-rent control?
Not rent control.
Okay, so for not rent control, you can do rent increases of basically up to 10%. And that 10% is because of the state emergency. Are we talking about residential?
Yes.
Okay, so yeah, up to 10%. There are circumstances where you can do more than 10%. Again, you'd have to qualify for very specific exceptions that are in the penal code of the state anti-gouging law. So again, we can talk offline to see if you might qualify, but as a general rule, you can go up to 10% right now.
Okay, great. Thank you.
For non-rent control, no state, no county, no city, just so everyone is clear.
So that's all the questions I've seen come through, Niv.
Hold on one second. We say Ezzy is asking, are we allowed to issue a 15-day notice to pay rent or quit in the city of Los Angeles? Yes. Now, if you call housing, they'll tell you no. The thing is that according to the city moratorium, the only tenants that are protected are tenants who have a COVID-19 decrease in income because of a COVID-19 circumstance. It's not like every single tenant in the city of LA all of a sudden just has to not pay rent. If you give a 15-day notice, you can simply say, I have no indication that they have no ability to pay the rent. I'm just giving a 15-day notice because that's what the state forces me to do right now, right? But if you have, so basically you're saying, as far as I know, and this has to be true, they can't have given you the notices and you play dumb. You have to have it be reasonably defendable that you don't know that this residential tenant doesn't have a COVID-19 defense. Now, let's say you give it to them. They ignore it. They don't send you back the declaration. That's proof that they don't have a COVID-19 problem, right? And so then they're not subject to the city moratorium, and they're just protected by the state one, and that's only if they give you back the declaration, which they fail to do, thereby subjecting them to eviction, right? If you call housing, they're just trying to protect everyone, and they'll tell you, no, you can't do it. But it's more nuanced than that. Okay, let's see if we have any other questions.
I see one
Okay.
from Maurice. If a tenant is not being affected by COVID, is working full-time as a high-income earner and has not submitted declarations, can they be evicted?
Yes. So basically, if they're not following the rules and they're just saying, well, I'm making a bunch of money, but I'm hearing online that I don't have to pay the rent, I don't really feel like paying the rent, but they're going to their job or they're doing their job at home and they're still making money, you send them the 15-day notice. If they are making less than 130% of the AMI and they give you a declaration and you have a really good reason to believe that the declaration is false, you can still try the eviction, although like I said, it's very hard. If they're making more than 130% of the AMI, then they have to check the box when you do the 15-day notice. They have to give you proof that they have less money now. And if they don't give you good proof, or if they don't give you back that declaration, you can go ahead and file that eviction. So Tim was asking, what proof does a tenant have to produce to show that they have a decreased pay due to the payment besides the declaration? Are you able to verify? So if you're making less than 130% of the AMI, pretty much they don't have to verify. If they're making more than 130% of the AMI, according to the Los Angeles City moratorium, they don't have to verify. According to the state, they do, right? So I would always just check the box and push as far as you can until someone pushes back. So check the box and make sure they give some sort of proof, right? They are under a burden to produce the proof. What can they produce? They can show you bank statements. They can show you pay stubs before and after. They can theoretically maybe show you tax returns, like a 2019 to a 2020 tax return. Any of the normal evidence that you would produce to show a decrease in income or to show what your income was and now is would be proof. They can even produce, technically speaking, a letter from an employer. However, if that's the only thing they produce, I would be a little weary of that because they can always just get their employer to sign the document and lie for them, or it could just be forged. So I would want to see some sort of actual physical evidence like bank statements, tax returns, or pay stubs. How does the regional CPI, Beverly is asking, play into the rent rate calculations in a not rent control area? So again, the regional CPI only matters in terms of raising the rent if your building is subject to what we're calling the state rent control, right? So the AB 1482 that was passed 2 years ago. How does it play in? It basically works like this. In April of every year, you have the new CPI that they publish, which they'll publish next month. And the amount of rent that you can raise on any tenant after their term is expired is 5% plus whatever that CPI is. So in 2020, or sorry, in 2019, it was depending on where you are, it was anywhere between 7 to 8% because the CPI was a very healthy number. In 2020, because the statute forces you to take the CPI number from April of 2020, as most of you could probably remember, April 2020 was when the economy essentially crashed because of COVID for a little while. The CPI in, for example, LA County went down to 0.7. So for the entire year, the rent increase limit was 5.7. I am anticipating that next month it'll be a lot healthier. And so you use whatever your local CPI is, add to that 5%, that is your maximum rent increase limit for the following 12 months. If you are not subject to AB 1482, then the local regional CPI doesn't play into your increases at all. And in fact, you have no limit except for the emergency order and the state anti-price gouging statutes that we talked about earlier. Who has to provide the declaration? The declaration is any of the tenants. So it doesn't have to be all of them. It could just be one or more of the tenants living in the unit. Let's see. Did we not answer any other questions? Okay.
Niv, see if there were any sent to you privately. Some messages were sent on a general chat, some were sent to me, and then I'm sure some were sent to you directly.
Yeah, I'm looking in my chat window, and I think I tried to catch all of those. So, anybody else have any more questions? No? So if no one else has any more questions, thank you so much for coming on our webinar. I really enjoyed getting to talk to you guys and answer all your questions. We just put up all of our contact information for the, if you need to contact any of us. Our main line, it says, is 818-661-2420. My mobile number, you can reach me on it anytime, is 310-877-2834. And our email address to reach me is niv, N-I-V, at davidovichlaw.com. That's N-I-V at DAVIDovichlaw.com. And our website where you can watch the blog and watch the replay is davidovichlaw.com/blog. Okay, will the recording be available? Yeah, we're going to put it up, I think, hopefully tomorrow on the blog, so you can catch up and write down anything that you might have missed. But if you have any questions that were not covered by this, or you have one of those specific unique circumstances that you wanted to discuss, or really any other landlord, tenant, or real estate or construction related question, we're here to help you guys out and be of service to the real estate community. So thank you so much for coming. I really hope you enjoyed it. And
Thank you, David.
No problem. I hope to talk to all of you very soon.
Thank you.
Thanks, Niv.
Thanks, everybody. No problem.
Thank you.
Thank you.
No problem. No problem. Thanks for coming.
Yeah, free.
We love you.
Love you too. This is the closest I come to feeling like a rock star. Sad.